Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifted. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Welcome to the channel. If you are new here, welcome back if you've been here before. And thank you so much for everyone for hitting the like button and subscribing to the channel if you have not done so already. Now, on yesterday, the internet was shooketh because Busby, who has brought several Jane and John Doe lawsuits against P. Diddy, decided to amend an October complaint of which he mentioned a celebrity A and B. Now, before he decided to do this amendment, there was a lawsuit filed against Busby by a powerful celebrity who basically claimed that they were being extorted by Busby, i.e., there was a demand letter that was sent, and the demand letter was basically like, you need to mediate this, or you're going to be named in the lawsuit. Interestingly enough, back in October, Busby filed this lawsuit. Allegedly, the demand letter didn't happen until, I believe, sometime after that, perhaps. But nonetheless, Jay-Z said he filed a lawsuit against Busby like, listen, you ain't about to be extorting me. And the response was from Busby is he's not going to be intimidated. He's going to release this. Essentially, he said he was going to go ahead and release the name in a lawsuit. And that is what he did yesterday, was shook at the internet, of which he did what's called amended the complaint. Some people have been calling it resubmitted, refiled. I heard all type of no. It was an amendment, which is something that occurs oftentimes when you want to add parties. That's why you put John Does, because sometimes until you do investigation, you don't know who the John Does are, the Jane Does are, and you may find certain people that should be included in the lawsuit, or as you go on, you may want to add more claims because you find out it was more grimier than you thought it was. For whatever reason, amendments is not anything that is uncommon, even though people have made the clickbait very salacious. It's not that deep. However, what's interesting about this amendment is obviously Busby knew who celebrity A was. And instead of adding him originally in the complaint, he opted to leave him as celebrity A and do a demand letter and say, hey, we can go ahead and we can do a private mediation. Now, what has always interested me is, why would Jay-Z be saved if you didn't want to save Diddy? I guess because Diddy's name was already being dragged in the street. It was like, hey, we might as well go ahead and I don't know. But now I don't even want to, I guess I can't speculate as to why he chose this route. But nonetheless, he added Jay-Z. Jay-Z immediately provided a statement. So obviously he was waiting on this day to happen. This statement was not a statement from bougie PR firm. This statement was by Jay-Z from Brooklyn. Okay. Jay-Z essentially said, you're not getting one red cent, in all caps. Told him you are a deplorable, despicable human being. He also said that basically, why don't you call the feds? You know, why are you file a criminal complaint? Why are you filing a civil complaint? And what is being alleged under the statute, people have asked me about statute of limitation, there's no statute of limitation when it comes to essays and all of that, to an extent when it comes federally. Of course, there's always exceptions to the rule, but for the most part, probably a criminal case could be filed if that was that should be done. I mean, look, they're coming after Diddy for some, not for the kid part, but some actual allegations. They're coming after for prostitution, for the Abercrombie and Fitch guy. Nonetheless, he said, go talk to your local police officer. Why are you filing a civil lawsuit? Then he told him he was an ambulance chaser. With a cheap suit. So then Busby went to his Instagram and he decided that he wanted to let him know that, yes, this is me. This is a picture of me. I am I was in the military. I'm a Marine, I think he said. And he was like, I was that guy. I'm still that guy, and put it in all caps. All right. So they were going back and forth. Now, again, Busby filed this lawsuit on a Sunday when the courts are closed. So they wouldn't even really receive this amendment until for real today, when it would be considered, a part of the docket. But he also, when he filed it, Busby asked that this Jane Doe, who is accusing Jay-Z, remain anonymous. What is again interesting about that is that part of what Busby was saying was basically Jay-Z filed this lawsuit against Busby and allegedly was trying to get investigators and all these people to intimidate and harass the alleged accused's family or all these people surrounding Busby. And they're not going to be shooketh. And the rationale was that, I guess she said, go ahead and file it and add them to it. As if, from my understanding, this is supposed to be Jane Doe's idea. But interestingly enough, Jane Doe still wants to be Jane Doe, doesn't want to be out here. So what Busby did was, along with the complaint, he still requested that Jane Doe be allowed to continuously proceed as Jane Doe. Now, early Monday morning, Alex Spiro, who is the attorney for Jay-Z, he is also the one that's representing Mayor Eric Adams right now. He was up really early before the crack of dawn, apparently, for the crack of dawn. And he entered an appearance. He said, you ain't got to chase us down. You don't have to figure out where we're at. I'm going to enter an appearance because this is about to be the fight of your life. That's pretty much what Jay-Z was saying. He said, you got the right one, baby. And he said he wanted all the smoke. All right. So what Spiro did was he entered an appearance. Now, mind you, this is before, I don't even think a summons to serve him is even out yet. But he was like, I'm entering appearance and I am going to oppose you being allowed to be Jane Doe. Tell us who you are. We feel like you should say who you are, Jane Doe, since you're making all these egregious allegations against me. And Spiro has already filed that brief. I don't know if it was pre-typed, because if it was not, he was really mad when he was typing because he got a whole lot of pages done in a small amount of time because he had this file, I think, before noon. All right. So what we are going to go over is Spiro's motion opposing Jane Doe to be allowed to continue as Jane Doe. Said you have got to reveal yourself. You done said who I am. All right. You done named me in the pleading and I was celebrity A. I tried to be John Doe when I sued you. But since you want to put my name out there, now I got to sit down. Just as Jay-Z said, he had to sit down with his wife and discuss with his kids about how some people is just money hungry and they try to go for the money grabs. And he said, now there's another innocent person, which is his kid, that has to endure all of this because she's on the internet and she's old enough. So since I got to put myself out there, I'm going to need you to put yourself out there. So that right there, intellects, is the summary before we get into what was filed by Alex Spiro. Please hit that like button as you come in. Subscribe to the channel if you had not done so already. Them folks said he want to fight and he about to get one. That's what it's looking like. For Always Forever said, I have a question. If a person files a case as a doe, how can the defense fight a case on somebody when they don't know who's suing them? That is a great question. So what typically happens is doe as it relates to the public. However, of course, the plaintiff is revealed to the defendant. But if they decide to file motions, if the judge believes that this person can remain anonymous and go forward as doe, they're just going to go forward as anonymous throughout this whole proceeding, the litigation proceeding. I believe at trial they have, that's public. They might not be able to put their faces on the screen and all of that, but this is federal court, so ain't gonna be no cameras anyway. But just to answer your question, yes, the plaintiff is going to know who their accuser is. They are entitled to that information. LM said all should be fair in the court, so name her. If she's telling the truth, she should be fine. It's my opinion, Boo said he didn't do it. Selective listening. I'm always in support of victims, but there's literally no evidence yet against Jay-Z, so he's innocent until proven guilty. Well, all of these are just allegations. We already talked about that over here. These are all allegations. And again, this really isn't a guilt or innocence type of a situation because this is a civil case. If it was a criminal case, then of course he's presumed innocent until he is convicted or found guilty beyond a reasonable doubt. And that's not where we are right here. But that's what he said. He said, if you're alleging that this gruesome, heinous crime took place, go to the police. Why are you going to try to get money? That's what Jay-Z said. So she will most likely eventually have to be named. So there's been a mixture in the federal court. So there have been a few individuals that the court has made them reveal who they were. And it was the young lady, is it Anne, that was married to the NHL player. She had to reveal herself just recently. That was from the Detroit case against Sean Diddy. But what the courts oftentimes do is they'll let you remain anonymous in the beginning. But then if the defense comes in and they want to say, hey, no, name who they are, and they'll argue it back and forth, the judge may change their mind. They'll let you do it for so long, and then eventually, in this case, what has been happening with these cases with Diddy is he's been able to file it. Few judges have said, nope, you need to name him immediately because you haven't given good cause for her not to name her name. Name who she is or who he is. So you got to release it immediately. That's been a few cases. And there's been some cases that said we'll allow you to continue, but once they get served, the other party can decide whether they agree or disagree with this, her or him continuing in a pseudonym, and then they would have to reveal themselves at that time once the court revisits it. So it's kind of been a mixture in this case, but just recently there's been a couple of times where the courts have said, no, you have to name yourself almost immediately. So yeah. Let's see. You know what, one of one? Thank you so much for being a member for 9 months. She said, Busby gets very much sleazy. Well, that is alleged. You know, that is her opinion. So what has been filed is defendant Sean Carter's motion to deny plaintiff's request to proceed anonymously pursuant to Federal Rules of Civil Procedures 10A, or to dismiss the complaint pursuant to Federal Rules of Civil Procedures 12B1. I know this intro is going to be nice and sassy, so let's read it. For months, an extraordinary campaign has been targeting this named defendant under cover of darkness. That campaign was cynical and calculated to force payment of an exorbitant sum of money. Defendant would have to pay X millions of dollars irrespective of the truth, or else, ... When defendant refused to pay and instead took measures to establish his innocence, this unnamed plaintiff and her self-promoting counsel, whose name has been splashed across headlines and press conferences around under auspices of representing her, went to extraordinary lengths to shut down fair defense. But those efforts too failed. Now at last, the false, unfounded allegations that underlie this campaign of extortion are having judicial light shined on them, except that the plaintiff is bringing them as a doe who would continue to hide under cover of darkness. Because the tactics is inconsistent with the genuine effort to determine the truth or falsity of these allegations, as opposed to an effort to procure a quick, exorbitant settlement, defendant is respectfully seeking either dismissal of the allegations or disclosure of the plaintiff's identity. Fair is fair. It is not consistent with justice, fairness, or the rules governing federal proceedings for the plaintiff and her counsel to smear defendant's good name in ways that are calculated to feed media coverage and thus inflict maximum public relations damage, while the core fact of plaintiff's identity, revelation of which stands to discredit her entire case, remains wholly hidden from view. Whereas Doe's status is reserved for truly extraordinary cases and predicated upon extraordinary justifications, here a multitude of powerful considerations cut precisely the opposite directions, as other judges of this court have ruled in cases involving the same circumstances. He basically said, you think you're going to smear my name and then we're not going to say who you are? That's not going to work. Defendant Sean Carter, aka Jay-Z, has built an impeccable reputation. He has never been accused of, let alone engaged in, any actual misconduct until today, when plaintiff, in an amended complaint filed by attorney Anthony Busby, has leveled baseless allegations and accused Mr. Carter of despicable acts while hiding behind the pseudonym Jane Doe. These claims are not about justice for victims, nor are they about giving victims of actual violence a voice. Instead, they are merely the next chapter of attorney Busby's sprawling extortion saga, a saga whose aim is based and measured in dollars. Busby has devoted himself to the business of extracting large settlements from celebrities, high net worth individuals, and businesses with any public ties to Sean Combs, following his indictment for sex crimes in September 2024. References to justice or, quote, sunlight serve only a window dressing. Make no mistake, this case is about retaliating against the rare target who would not pay. Attorney Busby has a history of targeting celebrities by making false allegations of misconduct, and Mr. Carter sought to expose Attorney Busby's latest extortion scheme in California lawsuit on November 18, 2024, after receiving a demand letter from Attorney Busby. See Exhibit 1, the extortion complaint. We went over that yesterday, so if you have not seen that video, when we get finished, go back to the video from yesterday. At the same time, Attorney Busby knew who Mr. Carter was, even as Mr. Carter remained in the dark, as he does today, about the identity of Mr. Busby's client. So apparently Jay-Z doesn't even know who she is. Plaintiff and Attorney Busby now bring these claims against Mr. Carter in clear act of retaliation, as the complaint admits on its face. While Mr. Carter was being extorted, he could not speak out without revealing his identity and the heinous allegations made against him, which are patently false. that will be playing into attorney Busby's game and the leverage he is wielding. The upshot would be highly sensational and equally false allegations being broadcast across social media and the press, thereby maximizing the pressure exerted against extortion targets to satisfy his monetary demands, irrespective of the truth. Because Mr. Carter called upon the courts rather than paying, he has now been sued. So be it. One way or another, Mr. Carter is entitled and positioned to exonerate himself through the legal process. In this case, he will vigorously defend himself and expose the truth that the allegations in the complaint are false. But disclosure of plaintiff's identity is among the most essential basic tools that can and should enable Mr. Carter to vindicate himself. Mr. Carter should not have to defend himself in the brightest of spotlights against an accuser who hides in complete darkness while leveling allegations that describe the purported acts occurring in the plain sight of witnesses who could refute the plaintiff's claims if only her identity was revealed. See the amended complaint. In this American judicial system, lawsuits are public by their nature and their design. The public is meant to know the facts involved and identities of the parties. Indeed, federal law requires that all parties litigate using their true names. Parties are exempted from the mandate only in exceptional cases where, for instance, allowing the party to proceed anonymously will protect him or her from physical violence, deportation, imprisonment, or severe harassment. Here, plaintiff has chosen to sue Mr. Carter anonymously using the pseudonym Jane Doe, yet has not alleged any facts that would allow her to sidestep the federal mandate requiring that all parties must litigate using their true names. Indeed, plaintiff's allegations exhibit none of the special circumstances necessary to allow her to litigate anonymously. To the contrary, her facially incredible allegations indicate that, unlike in many cases of alleged sexual misconduct, she has already been exposed in plain sight to countless witnesses whose truthful accounts would be helpfully and properly informed by specifications of her identity. Notably, she has not claimed severe harassment, threats of violence, or any ongoing interaction with Mr. Carter beyond communications through her attorney. Nor has plaintiff even submitted an affidavit alleging these types of special circumstances. Instead, she relies solely on a self-serving declaration from Attorney Busby. Attorney Busby's affidavit does not indicate how an attorney from Texas is competent to testify as to the mental state of plaintiff, let alone how he has personal knowledge of what happened to her in New York to supposedly cause that mental state. The declaration does little more than parrot Busby's own motivations and legal standard. That is, it does not provide any actual facts indicating that plaintiff is in need of extraordinary protection. Suffice it to say that attorney proffered innuendo and generic accusations do not suffice to justify why Mr. Carter and the American public should be denied access to plaintiff's identity in this highly public litigation. If anything, this case presents an extraordinary need to follow the ordinary rules of litigation and have both parties proceed under their actual names. Attorney Busby has for months taken to traditional and social media to describe how he planned to target celebrities in connection with these allegations. And he has now issued multiple social media posts about this action. Traditional media sources have somehow been reporting, with Busby's express endorsement on social media, that Mr. Carter is the target of Busby's allegations. Thus, the plaintiff, through her counsel, has acted quite unlike a party who wants to minimize the amount of public attention on this matter. Instead, Busby has attempted to leverage public scrutiny to taint a potential jury pool and put pressure on Mr. Carter to settle this meritless case. In those circumstances, it would be extraordinarily unfair if the plaintiff could continue to hide behind the shield and anonymity while leveraging public interest, in this case strategically, to pressure the defendant. Furthermore, the allegations here describe serious criminal violation. It is fundamental in the American legal tradition that a person accused of such actions has the right to know the identity of the accuser and confront that person in open court. Moreover, the amended complaint itself makes clear this is all what this is all about. Not justice, but quick and large settlements against a celebrity. The amended complaint on its face alleges that Busby chose to sue Mr. Carter because he fought back against Busby's extraordinary tactics. As Busby subsequently tweeted, Mr. Carter's conduct in defending himself has had the opposite impact because, in Busby's word, quote, plaintiff is emboldened, end quote. And although the complaint alleges that another celebrity, Celebrity B, was also involved in the alleged action, it does not reveal her identity. No doubt, because Busby seeks to leverage his public allegations against Mr. Carter to extract a settlement from her. None of this is consistent with a genuine effort to seek justice and truth. This court should not allow this strategic abuse of the judicial system to continue. Mr. Carter deserves to know the identity of the person who is effectively accusing him in sensationalized publicity hunting fashion of criminal conduct, demanding massive financial compensation and tarnishing a reputation earned over decades. This court has recognized the nearly identical claims brought by other plaintiffs represented by attorney Busby do not meet the criteria to proceed anonymously. Here, the balance of the equities afford all the more reason why this plaintiff should be proceeding under her true name if she wishes to proceed at all. So basically, if you need to decide whether to say who you are or drop this lawsuit. That is the background. I mean, not the background. That's the intro. We haven't even gotten to the background. Crunk Girl 711 said that lawyer is on they arse. Course correction said, yeah, once accused, even if you win a trial, your name is never really cleared. The win won't be covered like the accusation, and a lot of people will still believe it. Tanya, I had your super chat up here earlier and I forgot to thank you. Thank you so much for the super chat. She said, thank you, beautiful Pam. Thank you so much. And thank you for the compliment. I appreciate that. Oh my gosh. This just got real. Why did she go to this attorney and not another attorney? Angie, how do we know that she didn't? I think that's an assumption that she went to just this attorney. It could have been she went to other attorneys and they were like, they weren't interested. You know, they got that letter declining representation, which we all send out every now and then when somebody comes to us and we're like, yeah, we choose not to represent you, but we don't want to discourage you from going to someone else because someone else may take your case. So we don't know if this is the only attorney that she went to. Really Sunshine said, we can all agree that Jay-Z is powerful behind the scenes, correct? Why would she put her identity out there so his shooters can come after her? Be for real. That is from Really Sunshine. And my response to you would be, because that's what the law requires. If you're going to sue, then you're going to have to put your name out there unless there's extraordinary circumstances. There was no affidavit that was attached to Busby's motion that basically made allegations like what you just alleged, that there were shooters out there or people were harassing her or stalking her, or, you know, she was concerned about it. It sounds like to me, Jay-Z doesn't even know who the person is. So those allegations have not been placed out there. A lot of the assumptions that's been given to the court is because he has money and he has power, that means he has the ability to do so. If that's the case, then everybody with money, if they get sued, they would never have to go under their real names. They can go under a pseudonym. Will that be fair? Or is that a slippery slope? That whenever there's a multimillionaire or a billionaire or someone, quote, with power, then you get to remain anonymous because they got the resources to do things, even though they haven't necessarily done it to you. But thank you for the comment. I really thought Jigga was going to pay up. I believe Busby thought Jay-Z wouldn't fight this. Well, you guys, please hit that like button as you come in. We are going to continue with the reading that Jay-Z's attorney has filed this morning after entering an appearance saying, I heard you were looking for me. Here I go. In my cashed out voice. That's pretty much what he did this morning, and also said, your motion to try to continue as Jane Doe, we're fighting that. We're opposing that, and it should not be allowed in this case, just like it was not allowed in other cases that have been filed by Busby against Diddy. The Gold Experience said both parties should reveal their name. Let's go on. Let's move on. The background says an amended complaint filed on December 8, 2024, plaintiff sued Mr. Carter anonymously using the pseudonym Jane Doe, without filing her own affidavit supporting her request to be anonymous, because I'll be messing that word up. Plaintiff instead relies solely on a declaration submitted by attorney Busby. That declaration effectively parrots those attorney Busby has filed in other cases alleging claims of sexual assault by Sean Combs and others. More importantly, this declaration makes no specific reference to special circumstances unique to plaintiff's case. Instead, it only makes broad and generalized assertions about attorney Busby's other clients. And then it has the declaration. Strikingly, an overwhelming number of the clients, likely in excess of 80%, have stated to me or attorneys at my firm during their intake process that Mr. Combs made threats of violence against them. So I guess that's what he was putting in the declaration. Or against clients' family members, if the client disclosed to anyone the fact of the actual assault or other acts of Mr. Combs of which they were a victim. So basically in the affidavit, it sounds like Busby relied on the clients that at intake he talked to, and they all were saying basically that an overwhelming number of these people have said that Mr. Combs has made threats of violence against them or their family member. And so he's using that as a basis to say that this individual should be able to remain anonymous. In at least 2 cases filed by attorney Busby with this declaration, other courts in this district have already denied his baseless motions to proceed anonymously for failure to meet the burden to show each plaintiff was entitled to the exceptional remedy of anonymity. And so then they attached Exhibit 2 from an October 30th, 2024 order, where in that case, the court concludes that the balance of interest at stake weighs strongly against granting plaintiff's motion, where plaintiff, who is an adult, has now decided to file a lawsuit in which she accuses a famous person of engaging in heinous conduct approximately 20 years ago, end quote. And defendants have a right to defend themselves, including by investigating plaintiff, and the people have a right to know who is using their courts, end quote. So the court said we have a right as taxpayers to know who is using our courts that we are paying for. And that was in a February 29, 2024 order. That was October 30th, 2024. There was Exhibit 3, where there was a February 29, 2024 order that says, while the court does not take plaintiff's concerns lightly, the court cannot rely on generalized, uncorroborated claims that disclosure would harm plaintiff to justify her anonymity. Those cases concern Combs, who is under indictment and detained following a raft of criminal and civil allegations against him. But plaintiff has now sought to sully the reputation of Mr. Carter, who has never been accused of misconduct in his 37 adult years. Plaintiff has not come close to meeting her burden here and the balance of equities that she litigate under her true name. There is every indication that this lawsuit is not truly about plaintiff, but about attorney Busby's larger unsavory agenda. Despite plaintiff's request to proceed anonymously, plaintiff's counsel is doing everything to draw widespread attention to her. Basically, you want to be anonymous, but your attorney is doing the most. The same day the amended complaint was filed naming Mr. Carter, attorney Busby posted on Instagram and Twitter prominently featuring himself addressing the amended complaint and making clear this is not about his clients, but it is about his personal spat with Mr. Carter. And then they have Exhibit 4 and Exhibit 8, which we read yesterday, but we can refresh our recollections right now, where this post said, regarding the Jay-Z case and his efforts to silence my clients, Mr. Carter previously denied being the one who sued me and my firm. He filed his frivolous case under a pseudonym. What he fails to say in his recent statement is my firm sent his lawyer a demand letter on behalf of an alleged victim, and that victim never demanded a penny from him. Instead, she only sought a confidential mediation. If you're asking for mediation, you're asking for money. What else would you be asking for in a mediation? Just assuming there were no numbers in this demand. You are not asking for a mediation because you guys are just going to kumbaya and you're going to say, Jay-Z, if you just say sorry, then I'll go away. That's good enough. No, you're going to ask for money. So let's not, play those games. Since I sent the letter on her behalf, Mr. Carter has not only sued me, but he has tried to bully and harass me and this plaintiff. His conduct has had the opposite impact. She is emboldened. I'm very proud of her resolve. As far as the allegations in the complaint filed, we will let the filing speak for itself and will litigate the facts in court, not in the media. It's too late for that, Mr. Busby. Then this one shows him as the first Lieutenant A.G. Busby platoon commander, where he said, recognize this guy? This is the picture of the weapons platoon commander, Alpha Company, 1st Battalion, 4th Marines from our old Western Pacific cruise book. Despite a coordinated and aggressive effort that has included harassing my kids, contacting my clients and former clients to encourage them to sue me, contacting my colleagues or former employees asking if, quote, I've ever abused them, showing up at my current employees' homes to harass them, filing frivolous cases against me and my law firm, defaming me with outrageous assertions to anyone who will listen, and having mysterious people follow me and my family. I'm still, all caps, that guy. I won't be bullied or intimidated. People will see through this effort to discredit me and my clients, and the truth will be revealed. I also won't allow anyone to scare my clients into silence. Sunlight is the best disinfectant, and I am quite certain the sun is coming. And so I made a comment yesterday when he used that quote, because I was like, well, before you didn't care about sunlight. So why are we talking about sunlight now? You didn't care about sunlight until Jay-Z sued you. Now you're like, oh, your name needs to be revealed now. But before, according to you, you were willing to have a mediation and just do this outside of the public, get a couple of dollars and keep it moving. Sunlight didn't matter. You were okay with doing it in the dark, until Jay-Z brought what was going on in his opinion to the light. So I just had to bring that out. What is more, attorney Busby has made numerous social media posts and statements to the media regarding his representation of individuals with allegations against Sean Combs, including that he would target other unnamed celebrities. These statements began a couple weeks after Mr. Combs' indictment and continued after plaintiff, through attorney Busby, sent Mr. Carter unfounded demand letter on November of 2024, falsely accusing him of RAPE. So remember, this original complaint, which had Jay-Z as celebrity A, I guess, was filed back in October. Apparently, it wasn't until November is when the demand letter came. These baseless claims, unsupported by evidence, are nothing more than a calculated effort to strong-arm Mr. Carter into submission. When Mr. Carter proved unwilling to pay, Attorney Busby escalated his tactics and schemed further, threatening to conjure additional false accusations and manufacturing a parade of fictitious additional victims to emerge and further damage Mr. Carter's reputation. To coerce Mr. Carter into compliance, plaintiff and attorney Busby imposed an arbitrary deadline in their extraordinary demand letter, warning Mr. Carter that they would take a different course, quote, if he did not agree to a confidential mediation to resolve this delicate and important matter, end quote. So, in Busby's defense on this one, typically in your demand letter, you put this demand letter is good for 14 days or something like that. That is not uncommon because I'm going to give you time to think about it, but then I got to do what I have to do because I do have statutes of limitations or other considerations that if I don't file, I may lose my claim. So that is not uncommon in a demand letter to say, give them a time limit in order to respond. And take a different course. Obviously, him saying that means you, just like we put, you have 14 days or we're going to file a lawsuit. It sounds like he didn't say that. He just said we'll have to take a different course. So on that, I don't see a real big deal on that being said. But of course, I will have to read the whole demand in its context. Okay. Without even waiting for the deadline provided by the extraordinary demand letter to pass, Attorney Busby posted on social media that he intended to file a lawsuit naming Mr. Carter and attaching the extraordinary demand letter to punish Mr. Carter for seeking redress from a court. All along, Mr. Carter refused to bow to Attorney Busby's scheme. Faced with the choice to either pay an exorbitant sum to silence plaintiff's wild false allegations of sexual assault, risking irreparable harm to his reputation, family, career, and livelihood, or face a barrage of baseless lawsuits and financial ruin, Mr. Carter stood his ground. On November 18, 2024, Mr. Carter filed a complaint against Attorney Busby and his law firm because of his conduct. In retaliation, plaintiff and Attorney Busby filed the amended complaint. They did so, however, only followed a failed attempt by Attorney Busby to obtain a restraining. What? Breaking news. In retaliation, plaintiff and Attorney Busby filed the amended complaint. They did so, however, only followed a failed attempt by Attorney Busby to obtain a restraining order against Mr. Carter's counsel? What? Not Attorney Busby tried to get a restraining order against Mr. Spiro. Now the lawyers are going back and forth. Notably, the amended complaint acknowledged that plaintiff, through her counsel, Attorney Busby, is only bringing these false claims against Mr. Carter in retaliation for his failure to respond to her pre-litigation demand letter. And they referred to the complaint. Plaintiff goes so far as to accuse Mr. Carter of filing an utterly frivolous lawsuit, orchestrating a conspiracy of harassment, bullying, and intimidating against plaintiff's lawyers, their families, employees, and former associates in an attempt to silence plaintiff from naming Jay-Z. Rather than citing a desire for compensation for any actual harm suffered, because there was none, plaintiff, through her counsel, apparently, quote, chose to file this amendment as a result of the egregious conduct perpetrated by Carter, end quote, against Attorney Busby, quite different from the plaintiff. These tactics are designed to silence the other extortion victims who, like Mr. Carter, have been targeted by Attorney Busby, not based on their perceived culpability, but the depth of their pockets. Attorney Busby's tactics send a clear message. Any individual who resists extraordinary demands will face public retaliation through highly publicized lawsuits. This strategy is designed to silence other victims of Attorney Busby's extortion while creating media spectacles to amplify unfounded claims and maximize monetary recoveries outside of court. that this plaintiff is suing only now after attorney Busby has been left stinging from personal rebukes and defeats, supplies positive proof of how he elevates his own interests above those of his clients. Okay, I'm gonna have to read that one time for the one time from Spiro. He said that this plaintiff is suing only now after attorney Busby has been left stinging from personal rebukes and defeats, supplies positive proof of how he elevates his own interests above those of clients. Wow. Basically said you were a sore loser. And because he didn't do what you wanted him to do and he filed this lawsuit, now you want to do this tit for tat, tit for tat. You're a sore loser. Needless to say, this proceeding should not be driven by attorney Busby's agenda or interest. It is about finding the facts, applying the law, and fairly adjudicating what is the actual truth. Mr. Carter now is entitled to defend himself against these allegations with the benefit of all the protections and mechanisms available to defendants. To be sure, attorney Busby's game has been to prevent Mr. Carter from defending himself while punching below the belt. Today, that game is at an end, and Mr. Carter's defense has begun, starting with plaintiff's unmasking. They are writing over there at Quinn Emanuel. They got some writers over there. Jay Vickers said, wow, Busby never mentioned he tried for a restraining order and was denied. Now he named Jay in amendment, aka retaliation for not getting a restraint. It's a lot going on here, Jay Vickers. This is all allegedly. We're just out here watching it as it's happening in real time. And we all did the side eye when we found out he was taking settlements in exchange for being named. That's weird. See, you guys are going back and forth here. Pretty Officer said 2025 is about to be lit. Sister Craft said, hey, Pam, your work never stops. Do you ever get rest? No, not really. Not really, but you know, gotta do what I gotta do. Andrea said, yeah, he just discredited himself. Even if some of his clients are being truthful, he just undermined any justice they could have received. It's unfortunate. Oh, man. Angie is asking questions about the facts of the case. No, I don't think we know how the 13-year-old got to the event. We don't know that. Thank you, Nestos Shackle Shuffle Walk of Shame, becoming a YouTube member. I appreciate that. Lindo said, I heard Jane Doe filed a police report years ago. Is that true, Lindell? I don't know. I never heard that, but I would assume that would be a part of the complaints, because the complaint said she went to the gas station. At the gas station, she didn't know who the attendant was. You know, that was years ago, but she asked to use the phone. She called her father. So I assume her father would probably be someone that she would call as someone corroborating what she's saying. She told her father that she had snuck out and wasn't supposed to and asked him to come pick her up. So I don't know. I think it would be in the complaint, but maybe he's trying to hold it as a smoking gun. But I haven't heard that before, Lindo. But thank you for the super chat. I appreciate that. Yes, Jay-Z is coming out swinging. Thank you, Peanut Said It, for being a member for 15 months. Let's get to it, y'all. Yes. In the complaint, she claims someone working for Diddy took her to the party. Yes, we know that part, but how she got... So the way the scene begins is she wants to go to the VMAs and she wants to get in. So somehow she gets to the VMAs. That part, we don't really know. How she got to the party was allegedly through someone who purported to work for Diddy. The way it was worded sounds like they don't know if he really did work for Diddy, but whoever it was, they held them out and represented themselves out to be working for Diddy. And that's supposed to be who took her to the party. Let's see. Why are you here? You can go. If you think it's unprofessional, you can go. In fact, block them. How about that? Now you don't have to worry. You don't even have to make those hard decisions. They need to expedite this complaint because I'm ready to know the results of this. Who lying or who telling the truth? It's so many different cases. This is going to stretch out. And honestly, I don't know how you do a civil lawsuit without having Diddy testify. And I think what his attorneys are trying to do is see how much of the cases they can get dismissed, how many claims they can get dismissed, and then perhaps maybe holding it off until his criminal case is over, because you don't want him testifying under oath to anything that can be used against him. You don't want that. So Ty said, I think she claimed a friend dropped her off at the VMAs. Okay, I'll go back to the video from the last night and confirm. Okay. Thank you. Springflower says she's right. Cat started 2024 off by lighting a match, and it's been blazing ever since. We need some water in 2025. We need Cat to come back and say, what did you see that other people didn't see? Thank you so much, Springflower, for the super chat. I appreciate that. Okay, so Andrea said, remember she was mixing and mingling with drugged out celebrities who were strangers who also didn't notice her at all, even though she said she had just mixed and mingled with her. Which one is it? I don't know. Sweet Apple said, if Bill can get it, so can Jay-Z. Springflower said, I've never seen Pam block somebody. You know? Hello, Pam. Is that why Diddy was upset that Jay-Z didn't reach out? Was Diddy upset? Where you hear that at? I don't know. I don't talk to Diddy, okay, Christine. He hasn't called me Colette, okay? He hasn't used his 300 minutes a month on me. So I don't know if there was something going on with Jay-Z. Maybe is that something his kids relayed? I don't know. I have no answer to that. Unless Diddy. I don't know. I don't put anything past anyone. Time will tell. Absolutely it will. Rock Chick said, even if Jay decides to settle his career as a rap, look at what happened to Jonathan Majors. Jonathan Majors, Jay-Z. I don't know if they're on the same wavelength. Jonathan Majors had like one major movie or something. Jay-Z, I think he would be considered on a whole different level. So, but we shall see. And again, these are just allegations. These are claims and a complaint, and that is it. That's all it is right now. And he has denied it. All right, let's go. Procedural history. On November 6, 2024, before Mr. Carter was named, the court provisionally granted the plaintiff's motion to proceed under a pseudonym in this case. That's what I was talking about earlier, where the court provisionally granted allowing it to proceed. So apparently that's what happened in this case too, before Carter was named. At that time, the only named individual was Mr. Combs, who was indicted and had a flood of allegations leveled at him by a myriad of plaintiffs at the same time. In that order, the court clarified that at the time it was entered, quote, the balance of these interests may shift as this matter proceeds and defendants deserve to be heard on the issue, end quote. On December 8th, plaintiff's counsel filed an amended complaint naming Mr. Carter, an upstanding public figure who has never been accused of anything like this in his life. Whew, I hope you can stand by this, Jay-Z. I hope folk don't start coming out now like, wait a minute. I hope you can stand by this, because you're saying this with your chest, okay? By plaintiff's own admission, Mr. Carter was named solely because Mr. Carter refused to cede to plaintiff's counsel's extraordinary demands. Plaintiff's counsel knows he cannot continue to proceed with these lawsuits anonymously. Indeed, another judge in this very courthouse, considering precisely the same circumstances presented by the plaintiff, here declined to permit that plaintiff to proceed anonymously. See McCrary versus Combs. Mr. Carter now brings this motion because circumstances have changed. What the amended complaint put at issue no longer reflects the interests of the plaintiff. It is now a vehicle serving the singular agenda of Attorney Busby. Lest there be any doubt, one need only look to the social media post Attorney Busby made concurrent with this filing. It features no image or symbolism related to any purported victim of sexual assault. It features only Attorney Busby himself. Plaintiff's amended complaint should be dismissed and the motion to proceed anonymously denied as moot. In the alternative, the court should require plaintiff to identify herself so that Mr. Carter can adequately defend himself against these baseless and spurious allegations. So now you get into the legal standard on how the court is to evaluate this request. A putative plaintiff must establish subject matter jurisdiction to proceed before the court, and thus the court must know who is seeking redress. The title of the complaint must name all the parties. Then it has the court rules and all of the different case law that stands for that proposition. This rule, which cannot be set aside lightly, serves the vital purpose of facilitating public scrutiny of judicial proceedings. And then there's another case. As the Second Circuit has explained, the people have a right to know who is using their courts. There's the case site for that. Indeed, the right is supported by the First Amendment. A district court can grant an exception to this rule, but only in exceptional circumstances, where the plaintiff has a substantial privacy interest that outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings. And then it has the case. Critically, a plaintiff seeking Critically, a plaintiff seeking anonymity, I keep saying it all kind of ways, must offer the courts more than just mere speculation to support their request. And the court must also consider the interests of the opposing party when making this determination. The Second Circuit has enumerated a non-exhaustive list of factors to determine whether plaintiff's interest outweighs the interests of both the public and the defendant. So these are the factors the court will consider. And what they do is you add the facts to the factors, and then you do a balancing. Let's see which one it weighs in favor. Is it more for the plaintiff or more for the defendant? So the first factor is whether the litigation involves matters that are highly sensitive and of a personal nature. I think that weighs for the plaintiff. Whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties. I don't think she's proven that, so I guess that goes to the defendant. Whether identification presents other harms and the likely severity of those harms, including whether the injury litigated against would be uncured as a result of the disclosure of the plaintiff's identity. Number 4, whether the plaintiff is particularly vulnerable to the possible harms of disclosure, particularly in light of her age. Sounds like it's an adult. So whether the suit is challenging the actions of the government or that of a private party. Whether the defendant is prejudiced by allowing the plaintiff to press her claims anonymously, whether the nature of that prejudice, if any, differs at any particular stage of the litigation, and whether any prejudice can be mitigated by the district court. I'm sure the defendant is going to say it prejudices them. Whether the plaintiff's identity has thus far been kept confidential. Yes, it has. Whether the public's interest in the litigation is furthered by requiring the plaintiff to disclose her identity. I think that goes for the defendant because he's made this a high-profile case. Whether because of the purely legal nature of the issues presented or otherwise, there is an atypically weak public interest in knowing the litigants' identities. And number 10, whether there are any alternative mechanisms for protecting the confidentiality of the plaintiff. So those are the factors that the court is to consider with the facts of this case on whether she should be able to proceed as Jane Doe or her identity be revealed. A district court is not required to discuss every factor or use any particular formulation, provided that it balances the interests at stake. Plaintiff must bear the burden of rebutting the presumption of open records and establishing that the balance of factors weigh in favor of proceeding pseudonymously. So this is their argument, and the title says plaintiff's motion should be denied in full and her identity disclosed immediately as required by the federal rules. The allegations in this lawsuit are not unique, nor are the circumstances exceptional so as to warrant the extreme accommodation of proceeding anonymously. Multiple judges in this very district to consider these issues have concluded as much and required the plaintiffs to provide the court, the defendants, and the public with their true names, even where the facts and circumstances were more supportive of relief. And then they have an example of another Combs case. Because there's even less reason to support being anonymous here, the court should require the plaintiff to reveal her identity or dismiss the case against Jay-Z. So now they go to the first prong, which is highly sensitive and personal allegations. Plaintiff's allegations as pleaded are highly sensitive and personal in that they describe an actual assault. So that would be for the plaintiff. However, allegations of actual assault by themselves are not sufficient to entitle a plaintiff to proceed under a pseudonym. So they have a case law that says even though that goes in her favor, in theory, that's not enough under the case law. Courts in this district have denied motions to proceed under pseudonyms despite concluding that the plaintiff's allegations were highly sensitive and personal. And then they give other cases, Shakur, that denied a motion despite concluding that the allegations of the complaint, that if the allegations of the complaint are true, plaintiff was the victim of a brutal actual assault and has very legitimate privacy concerns. Rapp v. Fowler, Doe v. Linnelli, Town. So they just listed a bunch of cases where, despite it being highly sensitive because it's actual in nature, the court was like, that's not enough. You still got to reveal who you are. Risk of harm to the plaintiffs or third parties. The second factor is whether identification poses a risk of retaliatory physical or mental harm to the plaintiff, or even more critically, to innocent non-parties. The plaintiff offers no evidence of any actual risk of harm to her whatsoever. Instead, Attorney Busby makes the speculative and conclusory allegations that appear to pertain primarily to other clients of her counsel, not to her. Courts have routinely rejected attempts by litigants to shoehorn themselves into the narrow exception to the names disclosed rule through such conclusory secondhand declaration. And then it has the case law that stands for that proposition. Mr. Carter vehemently denies the allegations, has no idea who plaintiff is. So Busby was claiming that Jay-Z allegedly was sending people to harass like the plaintiff, and that let me see. Let's go back up here. It has, since I sent the letter on her behalf, Mr. Carter has not only sued me, but he has tried to bully and harass me and this plaintiff. How is he doing that if he doesn't even know who the person is, allegedly? Okay. So Mr. Carter vehemently denies the allegation, has no idea who plaintiff is or who she could possibly be, and thus has had no known contact with plaintiff for the approximately 20 years since the alleged incident, which, even if it occurred, did not involve Mr. Carter, and there is no allegation of any threat to plaintiff in the complaint. Mr. Carter is a well-regarded public figure represented by competent counsel who, in contrast to plaintiff's counsel, intend to litigate this case through the court system rather than social media. One thing Alex Spiro gonna do is he is going to throw some shade, okay? He said Mr. Carter is a well-regarded public figure represented by competent counsel who, in contrast to plaintiff's counsel, intend to litigate this case through the court system rather than social media. In any event, Counsel has not identified any present threat of physical harm to plaintiff from anyone. Plaintiff's counsel stresses that other alleged victims he represents have stated that Mr. Combs made threats of violence against them or against the client's family members if the client disclosed to anyone the fact of the actual assault. But there is certainly no allegation that Carter ever threatened to harm plaintiff, nor could he or she, or nor could he, as he has no idea who she is. Plaintiff's counsel asserts without offering any evidence that plaintiff would, quote, certainly experience mental harm if she is forced to reveal her identity to the public. That was in the plaintiff's memo. In the context, public humiliation is not enough. So they have case law that said public humiliation is not enough. Now I say, where's your authority? Every time Spiro's making Spiro spitting these statements, he has the case law to back it up. Nor is it sufficient for plaintiff to put forth a generalized argument that revealing the identity of a victim of sexual assault would further victimize her. Accepting such an argument, quote, would be to hold that nearly any plaintiff alleging sexual assault could proceed anonymously, which simply is not the law in this here circuit. Rather, the courts require direct evidence linking disclosure of plaintiff's name to a specific injury. One court in this circuit allowed a plaintiff to proceed anonymously, where she submitted evidence from a medical professional who predicted that requiring disclosure of her name would cause psychological and emotional pain so intense that it would threaten her stability, her safety, and even her life. Even where such medical evidence is present, other factors may still tip the balance against permitting a plaintiff to proceed anonymously. Regardless of what type of direct evidence might support such a finding, it is well established that counsel's, quote, conclusory statements and speculations about mental harm to plaintiffs is insufficient. And they have all the case law for that. But as discussed above, there is no such evidence. Just the motion says so. He just said it in the motion with no evidence. Plaintiff's counsel has failed to provide any evidence, no statement from a mental health professional, no affidavit from the plaintiff herself, nor any corroborating proof to support the bare claim that disclosing plaintiff's identity would harm her mental health. Counsel's unsupported assertions are insufficient. Plaintiff must offer the court more than just mere speculation to justify proceeding anonymously. While Mr. Carter is a public figure, this does not outweigh his and the public's right to the customary and constitutionally embedded presumption of openness in judicial proceeding. Plaintiff has chosen to bring this lawsuit, leveling serious charges, and as such, she has put her credibility in issue. Moreover, her counsel has expended considerable time and energy publicizing this case, dragging Mr. Carter and countless other public figures into baseless litigation for his own pecuniary gain. Indeed, when Mr. Carter refused to succumb to the outrageous demands that Mr. Carter pay up, Attorney Busby immediately escalated. Within minutes of filing the amended complaint naming Mr. Carter, he posted about it on social media, prominently featuring himself, weaponizing the judicial process to amplify his unfounded accusations. The motivation for naming Mr. Carter here would not be more clear. It has nothing to do with justice for victim. It is all about Attorney Busby. As plaintiff's counsel has repeatedly claimed, quote, sunlight is the best disinfectant, end quote. See, I knew that quote was going to come back to haunt him. I knew it was. Thank you, Darva and Marquita, for the Cash App. I appreciate it. Let's see. Told y'all. Ms. Reezy, thank you so much. And Miss Darva, thank you. I appreciate that. So what do you got to say about the sunlight? Mr. Carter is entitled to investigate the plaintiff's background and challenge her allegations and her credibility in order to defend himself against these false accusations. Moreover, media outlets have a constitutional right to publish stories about this case. We better stand up for our freedoms. Further, many individuals who have made serious allegations against Combs have filed lawsuits in this district in their own names. So then they name all the people that have filed. Cassie did it in her name. Jones did it in his name. McKinney, English, Richard, Graves, and McCrary. All of these lawsuits involve sensitive allegations that could expose the plaintiff to scrutiny and embarrassment. Plaintiff has not shown that she is entitled to the exceptional remedy of being anonymous where there are not. Plaintiff does not contend that disclosure of her identity poses a risk of harm to any innocent non-parties, so this factor favors revelation of the plaintiff's identity. And then the footnote says allegations by plaintiff's counsel that routine investigative activities related to pending legal matters and other for our harassing should be disregarded. Plaintiff's counsel tried to prevent Quinn Emanuel from investigating Mr. Carter's claims of extortion by trying to enjoin the firm from contacting anyone related to the Busby law firm. That request was denied 2 days before the amended complaint was filed in this case, further evidencing attorney Busby's retaliatory behavior. So looks like on Friday, Busby tried to get some type of restraining order to stop, I guess, the investigative process that Quinn Emanuel was doing based related to these claims. And the court must have denied it. And it was last Friday. And so they're saying, ironically, on Sunday, he decided to amend this complaint and add Jay-Z after he lost that. Plaintiff's age weighs against anonymity. Plaintiff is not especially vulnerable, particularly in light of her age. Plaintiff is an adult now, 37 years old, and she has not identified any reason for the court to treat her as more vulnerable than the great run of adult plaintiffs who bring allegations of sexual assault in their own names. Thus, the fourth factor weighs against plaintiff's request to proceed under a pseudonym. Defendant's status as private party weighs against it. Courts are loath to grant a motion to proceed anonymously against private parties. Mr. Carter and all of the other defendants are private parties. As such, factor 5 weighs against the plaintiff. Prejudice to defendants weighs against being anonymous. The sixth sealed plaintiff factor is whether the defendant is prejudiced by allowing the plaintiff to press her claims anonymously. Relevant to this inquiry is whether defendant would experience difficulties in conducting discovery, the reputational damage, and the fundamental fairness of proceeding anonymously. Mr. Carter would be prejudiced in all of these respects. Counsel's assertion that Mr. Carter or other defendants need not know plaintiff's identity to file an answer and conduct discovery strain. But I think they're gonna, I don't know. Plaintiff asserts that the defendants will still have the right to depose or confer with any and all witnesses. Clearly, Mr. Carter needs to know plaintiff's identity to depose her and to prepare to depose her. That much is given. But Mr. Carter does not know who is falsely accusing him. He cannot thoroughly investigate her allegations and her background and otherwise prepare defense of her claims. See, typically they allow you to know, like I said earlier, they allow you to know who the actual plaintiff is. You're just not supposed to put it for the public to see. Plaintiff is bringing a lawsuit about an incident that allegedly occurred more than 24 years ago, which may be difficult to defend given the passage of time, even with information about plaintiff's identity, hamstringing Mr. Carter by preventing him from even knowing where to begin his investigation. That cannot be permitted. See CTS Court v. Waldberger, which is the United States Supreme Court case. Plaintiff counsel confidentially disclosing plaintiff's name to defense counsel would not obviate the potential prejudice. Yeah, so that's why I'm saying I know they'll disclose it to the actual defendant, or the defense counsel. Highly publicized cases can cause unknown witnesses to surface. However, if plaintiff's name is kept from the public, information about only one side may thus come to light. In particular, persons with information about plaintiff or her allegations that would be helpful to the defense likely would have no way of knowing to come forward. So he's basically saying that if you keep it just with me being out here, there may be people that have information about the person accusing me that may be beneficial to me. Or she was with me at that time. Oh, she made those same allegations against me. Things of that nature. I'm not saying that happened. I'm just saying things of that nature where when they see something that occurred, see that a lawsuit was filed against him, then they may have information that is helpful to Jay-Z. But if they don't know, the public has no clue who she is, then they're not going to be able to have the benefit of that information. However, the opposite can happen with Jay-Z because his name is out there. So like I said earlier, perhaps you may have people that try to give some type of alleged information related to Jay-Z. So saying it's unfair in that sense. This is especially true for a 2-decade-old case where Mr. Carter is clearly prejudiced and at a disadvantage to defend himself and find witnesses and evidence to disprove the false allegations. Indeed, the potential prejudice to Mr. Carter with respect to discovery is inseparable from the potential prejudice to his reputation and fundamental fairness. Plaintiff alleges that a myriad named and as yet unnamed individuals and entities engaged in or facilitated heinous conduct with Mr. Combs were complicit in the same. And then there's a footnote. Mr. Carter adamantly denies the allegation with respect to his involvement. If damaging information about only one side is aired through the litigation, Mr. Carter cannot mitigate the damages to his reputation from being included in these false claims. Thus, courts in this circuit have long stressed the fundamental unfairness of allowing a plaintiff to, quote, make her accusations from behind a cloak of being anonymous. This factor accordingly weighs against being anonymous. Confidentiality of plaintiff's identity to date. The 7th seal plaintiff factor is whether the plaintiff identity has thus far been kept confidential. If confidentiality has not been maintained, courts typically reject a motion to proceed under a pseudonym. Plaintiff's counsel represents that plaintiff has not spoken publicly about the incident she alleges in the complaint. Plaintiff may have spoken privately to an unknown number of people without having ever, quote, received assurances of confidentiality from any of them. Plaintiff's counsel has broadcast the case against Combs widely in the news media, where he has threatened to name countless other celebrities and high-profile individuals as defendants. And within minutes of filing the amended complaint, in this case, he has already blasted it across his social media. Quite clearly, the confidentiality of this proceeding is not paramount to plaintiff or her counsel acting on her behalf. Plaintiff and her counsel cannot be permitted to wage a public smear campaign against Mr. Carter and his counsel while hiding behind a veil of being anonymous. Yeah, he kind of beat around the bush with this factor. He's like, your attorney been up there talking about this whole lawsuit, so clearly he doesn't want it to be a secret. He kind of beat around the bush. He's not going to concede anything, I see. I think this would actually weigh in favor of the plaintiff. The public interest weighs against being anonymous. Yeah, he was like that, tap dancing, like, whew. Okay. We're reaching the end, guys. Make sure you hit that like button. It's a lot. It's a lot going on in this motion. The public interest weighs against being anonymous. The 8th seal plaintiff factor is whether the public's interest in this litigation is furthered by requiring the plaintiff to disclose her identity. The 9th factor is whether, because of the purely legal nature of the issue presented, there is an atypically weak public interest in knowing the litigant's identity. These factors clearly weigh against granting plaintiff's motion to proceed under a pseudonym. As a rule, lawsuits are public events and the public has a legitimate interest in knowing the facts involved in them. Among those facts is the identity of the parties. There is undeniable public interest in the allegations against Mr. Carter and the identities of his accusers. This is not a case that involves abstract challenges to public policies, but rather particular actions and incidents. Thus, open proceedings benefit the public as well as the parties. Indeed, this is the kind of case that furthered the public's interest in enforcing legal and social norms. Plaintiff contends that the public interest favors granting her motion to proceed under a pseudonym so that victims of sexual assault will not be deterred from vindicating their rights. So the plaintiff is basically arguing that the public interest favors allowing her to remain Jane Doe so that other victims or alleged victims won't be deterred from using the court system out of fear that their name is going to be plastered on the complaint. However, as noted above, a number of other alleged victims have already sued Combs in their own names in this district. As such, those plaintiffs obviously were not deterred by the long line of previous cases in which courts in this district have rejected motions to proceed under a pseudonym brought by alleged victims of sexual assault who have made the same arguments about the public interest and possibility of deterrence. Moreover, there is a critical public interest in allowing the accused publicly to confront the accuser. If, notwithstanding that a number of other alleged victims have already sued in their own names, other potential plaintiffs are deterred by this decision from filing their own lawsuits, that is an unfortunate result of the fundamental countervailing interests that generally require plaintiffs and others like her to seek vindication of their right to publicity. The next fact, Jesus. The availability of alternative mechanisms. Jeez, oh Pete's, we are finally at the end of these factors. The final sealed plaintiff factor is whether any alternative mechanism short of proceeding under a pseudonym could protect plaintiff's interests and confidentiality. Sealed plaintiff is the name of the case. Plaintiff can seek less drastic remedies than blanket anonymity, such as redactions to protect particularly sensitive information or protective order. Thus, factor 10 weighs against plaintiff's motion. The balance of interest weighs against letting Jane Doe remain Jane Doe, according to Mr. Carter. The balance of interest at stake weighs strongly against granting plaintiff's motion to proceed under a pseudonym. The fundamental question is whether plaintiff has a substantial privacy interest that outweighs the customary and constitutionally embedded presumption of openness in judicial proceedings. Plaintiff, who is an adult, has now decided to file a lawsuit in which she accuses Mr. Carter of engaging in heinous conduct more than 20 years ago, and she has chosen to have her counsel loudly try this case in the media and the court of public opinion. Moreover, there is no evidence of exceptional circumstances that in and of themselves justify overriding the constitutional presumption of openness. Mr. Carter has a right to defend himself, including by investigating the plaintiff, and the people have a right to know who is using their courts. Plaintiff has not carried her burden to show that she is entitled to exceptional remedy here. Then he's like, Judge, if you don't feel like, dealing with these balances and stuff, you can just dismiss this case under Rule 12b1. So that's the last part. In the alternative, you should dismiss this complaint. A complaint that fails to adhere to Rule 10a is subject to dismissal under Rule 12b1 for lack of subject matter jurisdiction due to plaintiff's lack of standing. As detailed above, plaintiff's motion fails to meet the stringent requirements for the narrow exception for the rules. Numerous courts have rejected similarly vague and unsupported assertions at the pleading stage. Plaintiff has provided zero evidence, no affidavit, no declaration or specific factual support to establish the kind of severe harm necessary to justify coming in as a pseudonym. Her vague assertion of potential harm fall far short of the stringent requirement established by the Second Circuit and other federal courts. The lack of specificity in plaintiff's motion, combined with her counsel's public actions drawing attention to this litigation, undermines any claims that being anonymous is necessary to protect the privacy or safety. Moreover, plaintiff's failure to comply with Rule 10a deprives this court of subject matter jurisdiction. Federal courts lack jurisdiction over unnamed parties because such cases are not properly commenced. Without plaintiff's true identity, there is no justiciable controversy and the court cannot adjudicate the case. Plaintiff makes no effort to explain how litigation will work in practice without Mr. Carter knowing who plaintiff is. Accordingly, because plaintiff fails to meet the requirements for pseudonyms, and has not properly commenced this action, the court should deny her motion and dismiss the amended complaint under Rule 12B1. And that is the entire super long brief that I don't know how they wrote it that fast. I really don't. Let's see what some of these exhibits are. Opinion and order. Oh, that was another case. Let's see. Trying to see if it's any exhibits we just didn't see. Nope. We saw that one. We saw that. I needed somebody to post this harassing demand letter. That's what I want to see. That's what I want to observe. These harassing demand letters. It's the same thing with the TD Jakes case. I want to see what is being interpreted as harassment. That's what I want to know. Somebody get that answer for me. Let me see. Make sure you guys hit that like button for me. I appreciate that. I'm trying to see if one more thing before we get up out of here. In the Busby case. Well, Busby actually, did I put down what? Hold on. Let me make sure ain't nothing else been filed first too, because they're moving pretty rapidly in this case. Let's see. Motion to expedite. I knew they wrote something. You see what I'm saying? Oh, Jesus. Who wrote this? Quinn Emanuel. Listen, Jay-Z. Wait. We gotta go over this letter right quick. They done filed something else since we've been on here. Okay. All right, let's see what else they filed now. This was, okay. We write on behalf of our client, Sean Carter, concerning the inflammatory allegations made against him in the recently filed amended complaint. Based on the meritless and frivolous accusations, Mr. Carter filed a motion to deny plaintiff's request to proceed anonymously pursuant to Federal Rules of Civil Procedures 10A, or to dismiss the complaint pursuant to Federal Rules of Civil Procedures 12B1 this morning. Due to the highly sensitive nature of this matter and the intense media scrutiny it has generated, we respectfully request to be heard on an expedited basis. For the avoidance of doubt, Mr. Carter is entirely innocent. This is a shakedown. He is not mentioned, referenced, or implicated in any way in the criminal investigation of Mr. Combs. He is neither a target nor a person of interest in that investigation. Adding to the urgency of this matter, attorney Tony Busby has orchestrated a months-long press campaign aimed at inflaming public opinions and escalating the events in real time on social media platforms. Every day and in real time, Busby continues to amplify false narratives, exploiting the legal process to generate media attention and damage Mr. Carter's reputation. This relentless campaign underscores the need for a fast-track hearing to address these issues promptly and prevent further harm. Plaintiff request to proceed anonymously is both procedurally and proper and unsupported by law. Federal Rules of Civil Procedures 10A requires all parties to be named in their pleadings, reflecting the bedrock principle of transparency in the judicial proceeding. Plaintiff has failed to demonstrate any compelling circumstance that would justify an extraordinary departure from this rule. The speculative and unsubstantiated claims of harm presented by plaintiff's counsel do not meet the stringent standards required by the Second Circuit and other federal courts to allow pseudonymity. Furthermore, plaintiff's allegations, coupled with the conduct of her counsel, Anthony Busby, suggest a deliberate attempt to leverage the judicial process to generate unwarranted media attention and pressure Mr. Carter into a settlement. This misuse of the legal system undermines both its integrity and Mr. Carter's ability to defend himself effectively. It is critical that plaintiff's identity be disclosed so that Mr. Carter can investigate and respond to the claims fully and fairly. We further note that the timing of this filing coincides with ongoing media coverage of unrelated matters involving Mr. Combs' criminal trial in which Mr. Busby does not represent victims, underscoring the prejudicial and retaliatory nature of plaintiff's claim. The amended complaint appears designed not to seek justice, but rather to amplify unsubstantiated allegations and harm Mr. Carter's reputation by Anthony Busby. Allowing plaintiff to proceed anonymously would deny Mr. Carter the fundamental right to confront his accuser, while simultaneously enabling plaintiff and her counsel to conduct a trial by media. Given these circumstances, we respectfully urge the court to deny plaintiff's request to proceed anonymously and dismiss the complaint pursuant to Rule 12b-1. This matter is the utmost importance, and we request an expedited hearing to address these significant procedural and substantive issues. We are available at the court's earliest convenience to provide additional briefing or to appear for a hearing on this matter. Alex Spiro said, we can go right now. Do you got time this afternoon? Can you talk to us on your lunch break? Because we want to expedite this entire hearing. We're about to be on this case probably every day because Alex Spiro is not playing not nan games over here when it comes to this lawsuit and these allegations. I don't know about this case. Something don't seem clear in the complaint. That's from Christine Leach. Lotus Life says, so this a different 13-year-old that was revealed to be the lady they unveiled that is going through a bad divorce with the hockey player. No, the one with was married to the hockey player. That's the one from Detroit. And she was 17. She alleged she was like 17 or 16 or something. She wasn't 13. But no, this is a whole different person. And I thought it was a black lady on those, a black young lady that was on the pleading, but apparently she's white. And she was married to the hockey player. And from my understanding, she put him through hell. She accused him of some things and had an investigation for gambling. He had a restraining order against her. It was a lot going on with her too. So, yes, Lotus, this is the girl that was outside of the award show. Yes. Elite Leo said Alex Spiro has probably set aside everything in his life to be on top of this case. Alex Spiro is actually representing Eric Adams. So he has a few majors going on right now. But yeah, I've always known him for representing Jay-Z. He is the one that was able to, basically, he said, I didn't give a demand letter. I told, what is that show? I just talked, Piers Morgan. I told them that those comments made by Jaguar Wright, you take them down right now or else. And they just took it down. And Piers Morgan basically said, yeah, the show is called Uncensored, but basically we were going to take it down, period. Based on the stuff that Jaguar Wright alleged about Jay-Z and Beyonce. So apparently, he had that whole motion written and it was cites to different things that were filed by Busby Sunday. So almost sound like Busby was in there typing up some stuff because apparently something happened Friday. Then 2 weeks ago, you had Jay-Z who filed a lawsuit anonymously against Busby. And it just seems like a domino effect is happening. And so now Spiro is like on his head. He's on his neck. I hope Busby is ready for this fight. Diddy has Agnifilio and Shapiro. Jay-Z has Alex Spiro. Yes, that is correct. Agnifilio. I'm gonna keep my comments to myself. But Shapiro, like, it specializes in is that Shapiro that specializes in appeals? One of them specializes in appeal, not Agnifilio, but somebody specializes in appeals. This isn't about this one 13-year-old. It's about all the others that will come forward soon. Busby hoping for a class action. Taylor Durden. Apparently and allegedly, according to the alleged demand letter that we haven't seen yet, according to the demand letter, there was, I guess, alluding to that other people may come forward. He also said in the complaint, when you read when we read the complaint yesterday, he made it seem like this was not an isolated incident. So that he did say in the complaint. Amara Quinn, I don't know. Apparently they couldn't tell she was 13 and they just let her come into the adult party and gave her drinks, according to her. Seems like Jay-Z has better attorneys than Diddy's. Spiro's no joke. Alex is no joke, for sure. He is a great attorney. And he's been representing Jay-Z for years. And he's the one, remember, it was like he charges over, was it over $1,000 and something an hour? Because somebody asked how much he charges. How much did he charge? Somebody asked that in the Eric Adams Spiro. Let me see. His rate ain't no joke. Okay, so Alex Spiro, it had in People magazine, July 9th, Alex Spiro of the, let me see. He actually defended the Rust case too with Alex Baldwin. Remember they found it was that smoking gun where it was some Brady violations and they hadn't turned over some bullets. It was some smoking gun that Alex Spiro found and Alex Baldwin got acquitted. So let me pull up. It's the People's Magazine on him. One of the Alec Baldwin's defense attorneys in Russ case once charged $2,025 per hour. The hourly fee that attorney Alex Spiro charged another high-profile client was revealed in court documents obtained by People. Alec Baldwin has a high profile and it turns out expensive legal team fighting his involuntary manslaughter charge. Alex Spiro of the law firm of Quinn Emanuel, this is that Urquhart and Sullivan, has previously charged a client $2,025 per hour, an amount revealed in legal documents obtained by People. The Harvard-educated attorney, he went to Harvard, okay, who worked with billionaire Elon Musk during his takeover of Twitter, now known as X, charged the amount while representing Charlie Javis, an entrepreneur indicted on charges of fraud and conspiracy in 2023. Javis, who founded the student loan company Frank, sold her business to J.P. Morgan Chase for $175 million in 2021. But after the financial giant acquired the company, they claimed Javis falsely inflated the number of customers she had prior to the takeover. J.P. Morgan Chase sued her for fraud, and federal prosecutors soon brought criminal charges as well. A judge in the case ruled last year that J.P. Morgan Chase was legally obligated to pay Javis's attorney fees, and court documents associated with the case, Spiro's $2,025 per hour fee was revealed. It is unclear if Baldwin, 66, is paying Spiro that amount. Spiro, who is just one of several lawyers representing Baldwin, did not immediately reply to a request for comment about his past and current fees. If Baldwin were to pay that premium amount, a regular 40-hour work week would cost Baldwin $81,000 for Spiro alone. Spiro is also representing New York City Mayor Eric Adams in an sexual harassment lawsuit brought by a former aide. So he actually was representing Eric Adams when he was accused of sexual harassment. When all these lawsuits were going down a year ago, Eric Adams got accused too, but I think they made him withdraw as attorney because now he's Eric Adams' attorney on the criminal case. Okay. According to ABC News, Spiro is charging the embattled official only $250 per hour, a discount of more than 87%. Get out of here. According to Vanity Fair, Spiro has also represented Jay-Z, Mick Jagger, and Naomi Osaka. Baldwin is on trial for involuntary manslaughter. Yeah. You know he won that case, though. Well, I guess in the civil case, Tracy, he was only charging $250 an hour, because I believe that the city of New York has to pay for his defense, because he's accused of all of this stuff while still in office. So. Why would Jay-Z's lawyer file a motion to dismiss based on subject matter jurisdiction? The court obviously has subject matter jurisdiction. Now, Taylor Durden, because so this has happened before in another one of Diddy's cases. It depends on what judge that you have, but that's a good question. So on a pleading, you're supposed to say your name, generally speaking, unless the court allows you to proceed anonymously. What Busby had done prior to was he would just file these complaints with them being Jane and John Doe. One of the courts told him, if you don't file the motion and get permission, then I'm going to have to dismiss your case. So part of subject matter jurisdiction, as we provided when we went over the brief, is you're supposed to name who the parties are. So that's why. Low bono. We call it low bono, Tracy. When it's not necessarily free, but it's not necessarily your regular price. It's like low bono. I'm reducing my price for you specifically. But $250 is like, in New York too, that's probably like a associate, first year, second year associate or something, charging $250 in New York. Hey, Aunt Natty, good to see you. Let me see. You said I can afford 1/4 of an hour with Spiro. I don't even think you can even email him and respond. Shoot, it's too expensive. Grace Mercy says, is it too late for me to become a lawyer? It's never too late. A lot of people have being a lawyer as their second career. Pam, you heard about the old Luke interview with Jay-Z where two young women were having What? No, Lotus, I have not. I haven't heard that. Shoot, I got to step my game up. $2K an hour. I've been shortchanging myself. I would have been up there too all night. That type of money, as soon as they filed, I'm entering appearance. I'm typing up all my stuff. Look, he wrote a letter after he already filed the motion. All this stuff he gets the bill for. So after you've already filed this motion to respond, now on top of your charging, because you had to go on the internet, you had to look to see who was saying what, you had to look at Busby's Instagram, you guys screen grabbed it, and then you wrote out what he said. Then you had to read what Busby said in his motion. All of that stuff is a part of your hourly, rate. Every time you do something that has something to do with the case, he probably talked to Jay-Z 20 times yesterday, because Jay-Z was hot. When he read that statement yesterday, you guys heard it, he was hot. So he probably had to talk Jay-Z off the ledge, because he was on fire yesterday. Was like, I want all the smoke. Whatever you got to do, get to doing it, Alex. Whatever you need to do right now, I need you to get to doing it, okay? And that's probably what happened last night. And Alex has not gotten any rest. He wants to get in front of that judge immediately. So I'm sure he would prefer for the amended complaint to just get dismissed. And he's kind of putting it out there too. Yo, we know that your attorney has filed this, and you can dismiss this case if you want to, because you have the right to, as you being Jane Doe, or you're just going to have to say who you are. So we'll see how this goes, guys. Shay Bay said, thank you for your unbiased reporting. Thank you so much for being a member for 7 months. The Real Empress said, hey, Pammy Pam, thank you for always for your expertise. Thank you so much for being a member for 7 months. Karen Harris, thank you for the super chat. I appreciate that. Thank you so much for the support, y'all. Y'all got any other questions? I'm about to get out of here. Ty said, then Jay-Z say he ain't do it. Spiro say Busby a sore loser and Jane need to show herself. I think that's about sums it all up, right, y'all? Ty, pretty much. Jay-Z said, I'm innocent. He said, but you got the right one because I want water smoke. That's pretty much what he said yesterday, okay? Busby said, I ain't no punk neither. I'm a Marine. I'm still that guy. So I'm ready for any smoke you got. I'm not scared of you and I won't be intimidated. Spiro said, oh, all right. You said you down for it? All right, well, get ready. Put up your sword then, because we about to fight. All right. And then Spiro responded today like, listen, I'm so ready. I'm going to enter in my appearance right now. You ain't even got to wait for the court to issue a summons. You ain't got to do none of that. Just go ahead and I'm going to go. I got the complaint. I'll accept it. It is what it is. And I'm about to file this against you. Jay-Z name is out there. What's your name? Since we all put names out here today, why don't you say who you are since you don't put his name out there? You can't hide under the cloak of a mask, but then it's one-sided because now people can come forward and say negative things about Jay-Z or whatever they want. But when it comes to you, you just shielded the whole time. Absolutely not. It's not going to happen in this fight. I don't know what you used to and who you met. I don't know what you used to in this litigation. I don't know if people are scared of you or something, but my name is Alex Spiro, and I ain't scared of nobody. That's pretty much what he said. Pam, the men in chat would like to know if you are currently. I am married, Tyler Duden. I am married. You must be new here because everybody I thought knows that. Let's see. PW says, sounds like it's time for a lawyer. Ain't nothing like a lawyer fights. Oh, Lord, y'all done got my husband started. Lord Jesus. He said, he said, my apologies, no disrespect intended. Thank you so much for that apology, Tyler. I appreciate that. Course correction said, hopefully Busby is ready for the lawyering. Yeah, because this got real deep. All right, y'all. Make sure you hit that like button. I can't read nothing else. I don't know. I don't know if I'll be back or not because I just it's a lot going on. I guess I should check and see if something else that happened since I read that. Let's see. Oh man, let's see. No, nothing else has happened since the motion to expedite. That was the last thing that was on the docket. So we'll see what happens next. So Auntie Natty said she was waiting on you to pop up. Okay, can Eric Turkish friend pay for his, you know what? Tracy, you're gonna be held in contempt. I'm gonna need you to cut it out. All right, y'all. I'm out of here. Hope you guys enjoyed the video. Let me know that you did by hitting that like button and subscribe to the channel. I'll talk to you guys next time.